something fake where he just announces that he's launched a nuclear war or whatever. And you're just doing it for some purely nefarious reason. And you're doing the exact same thing. The video is identical. But you're doing it as a form of political commentary. And you're saying, look, I've made a very real example of what I think Trump is capable of. I didn't try to trick anyone, make them believe that he really said it. Well, is the first one copyright infringement and the second one isn't? Because of the intent? The videos are identical. Pixel for pixel. They're identical. Well, is one of them copyright infringement and the other one not copyright infringement? So there are complicated questions that would arise.
Yeah, no, that is really helpful.
If I can make a quick comment, is that go ahead, James.
No, I was saying, please. I'm
Thank you.
waiting with the.
Thank you. Oh, you shouldn't. It's not that profound. So how did the law manage to stop Napster and Grokster and all that? Right. I think that's a good question to ask to see what we can expect from the law here. What happened with that was that the court came out in no uncertain terms say, peer-to-peer sharing is copyright infringement. And as you said, some enterprising attorneys went around and sued a handful of people. It wasn't a very big deal. There weren't that many lawsuits, etc. But what happened was that companies realized this is not efficient, right? They can't just put their products out there and then go around and sue people who are copying them. That's extremely inefficient. So what do? Is that you can't really buy music anymore, right? The music that you get is all on streaming services. So you don't own your own copy of the music that now you can share with somebody else in a peer-to-peer thing. This happened with software as well, right? I mean, you don't buy software anymore. You don't have access to the source code. What you have is you buy a subscription to a web-based software thing, and you don't see the source code. You just have to have a subscription to the use of the software. You don't own the software. So what the law did was that initially it provided a means for remedy, but then it kind of told people that those means for remedy are insufficient, and you need to go find another way, a practical way of doing this, and people did that by removing the source code and by putting a whole bunch of coding in front of it so nobody could copy it. This is what I think is going to happen here, is that we're going to get some laws, but at the end, those laws are not going to be extremely effective. Instead, what we're going to find is another technology is going to come around so that people will take pictures and record voices and things like that using that technology so that it can't be copied anymore. That would be my guess for what's going to happen.
I'm confused. I mean, given the AI technology of simulating human likenesses and human voices, I mean, how does that tie into what you just said? I mean, there's really no copying involved.
No. That there's going to be a technology that can identify this thing as a copied as an AI image and not the real image.
Sam, let me just throw in a couple of quick thoughts here. So I know that the major business proprietary sort of answer has been where you can fingerprint things or you watermark things. And then this law, I believe, comes from the pool of thought where people say Yeah, but this is either currently or soon to be indistinguishable. There's no way to watermark it. And really quick, just last thing. And so, I'm sorry, I'm walking on this up. So the last thing is, okay, so 2 years ago I created this a legal brief AI assistant that has a non-attorney. I thought this is an interesting idea, so I worked on it for a bit. Not into the age of agentic, autonomous, voice simulating or internet scouring, agentic AI models. However, now if I were to go back to that, I would add a headless or a swarm of headless browsers, the ability to go on everywhere on the internet to work 24 hours a day, 7 days a week. And if I had enough GPU and compute power, I would have billions of these things scouring the universe for cases, kind of like prospectors looking for gold deposits around the world. I mean, does this in any way play into this? So if this law was enacted and there was a way to...
Sorry, I didn't really understand what you said. If you could explain it.
I do. Yeah, I mean, those exist today, right? Those exist. Let's put it in really general terms so it has nothing to do with Denmark or real people's faces. If you have a protectable asset where you are entitled to a remedy if that asset appears on the internet, is there a way to scour the internet to identify uses? So that you don't need to just hope that one of your buddies notices.
The Magus, the objects Mercury juggles represents different realms of communication. Coins, fire, wand, arrow, scroll, winged egg, cutlass, snake, sword, body, matter, finance, inspiration, transformation, dynamics.
Within your system of legal teamwork that you do in your private practice or wherever.
Well, again, I'm taking it outside of the context of legal particularly. I mean, real world examples. Reuters. Reuters does scan the internet. I mean, they don't do it themselves, but they have a company that does it, that just scans the internet constantly, searching for photos that are Reuters copyrighted. And it doesn't do it by identifying the subject of the photo or a human getting some envelope full of photos and then it looks at them. I mean, it's obviously all done digitally. And when they find a Reuters photo that's being used without authorization, they automatically send a takedown notification, a demand letter, et cetera, et cetera, et cetera. So there's no reason that same thing couldn't exist for every human face in Denmark, every human voice in Denmark. I don't think it will, for reasons I've already explained. It wouldn't be worth it, but the technology certainly exists.
Now, I recall you wanted to speak when I was sort of going on. Really, the word I was looking for was a paralegal agent, artificial agent. And Steve, you did kind of, in some ways, answer my question that this stuff already exists. Yeah, I know.
Yeah, I mean, in the patent world, we constantly do this, right? I have, for some clients, I have monthly. For some clients, I have weekly searches set up. There are companies who do this, that they basically scour scientific literature for some keywords that are specific to my client's technology, and if those keywords show up, we'll then look up to see, are they infringing our patent or not? This is routinely done. It's kind of like so routine that you talk to any IP attorney, they'll tell you the name of 5 companies that do this for them. So as Steve says, it's just a question of having the technology that can do that. It's not a question of, do we do these things or not? Yes, we do them.
So I want to just Dr. James, can I just clarify one other thing? Just because I always, no disrespect to Sam, nothing he has said is inaccurate. but I want to make sure people don't come away with the wrong impression. The Grokster case, everyone knew that the people using the peer-to-peer networks were committing copyright infringement. The question was whether Grokster was liable because they weren't doing any of the copying, right? They issued software that enabled people to infringe by copying music without Grokster or its servers being involved. So the novel, if there was a novel question, was Grokster's liability, even though Grokster wasn't the one doing the copying.
That's the connective tissue.
And the Supreme Court said, yes, even though you found a clever way to remove yourself from the copying chain, since you created the software, and this is really the only thing the software does, you are in effect secondarily liable. I mean, they weren't clear about which theory. They said one way or another, you're definitely liable for copyright.
But Steve,
So that was what was unique about the case.
Yes.
Is that they weren't doing any copying themselves.
I'd like to just
Their consumers were doing the copying.
really quick. So
Wait, Steve.
Wait, hold on.
Go ahead,
Let me just nudge it really quick. So I do see that as the connective tissue because I can imagine if I'm Denmark and I have really had it with Facebook fake news messing with my election cycle or other various things because I really value the rights of my citizens if that's the case. And I want to have a way to get some teeth into companies like Meta and other companies that propagate these things. Then you have a way to find per instance of copyright, probably larger sums of money against them, at least as a start towards fighting against it. And I just thought of one of the kind of quote unquote nefarious use cases that took me until now. So perhaps the thing it's tied to is not a number. Perhaps the face, the voice, the body become a new version of a fingerprint because we use fingerprints to personally identify people just like we use DNA. And so maybe the face, voice, and body are the new version of a fingerprint, including the iris and et cetera. And my question then is, for those privacy, people who value privacy, would they want that to be the case? Because I could see how then those pieces of information, those data are stored into some kind of central database, how that can have all sorts of problematic things for, personal privacy. And is this kind of the dawning of the death of privacy? Again, go ahead. I think that's all I have.
Okay, wait.
I'm sorry. I know I'm not an attorney, so I'm really
No. Well, the question that you ask is extremely fair. Going back to what Steve said, and that kind of ties in with what you're asking, is that the court in Grokster didn't come up with new law. Instead, it applied the already existing law in a novel situation.
Correct. Absolutely correct.
Whereas
You and
Denmark here is, on that we agree completely, right? It just said, look, this is copyright law. You're doing this based on our precedents. You're infringing. And when we read the decision, we're like, yeah, it sounds okay. But what Denmark is doing is setting up new law from what we understand what Denmark is trying to do. It is trying to set up new law which is completely at odds with the tradition of copyright law that we've had since WIPO was established in 1970. So I don't think these two are at all the same. And I also think that Dr. James, I don't think we need to sit here and devise new laws to deal with this. The first thing we have to do is kind of what the court in Grokster did. Apply the already existing laws. If they don't work, what was that?
Israel has so much security and so much, proof of who you are, I assume, that what do they do?
But the thing is that we have much stronger privacy and civil liberty laws than they do. So, and we're in a completely different security environment than they are. So some of these draconian measures that other countries use are not proper under our laws. So we could get inspiration from them, but we can't necessarily copy them. And so I was going to say, I think what's going to happen is that we're going to apply the existing laws and if they don't work, then the court signals Congress and says, guys, we need help here. Exactly what they did with the MCA, that the courts kind of like ran out of options for electronic and digital files. They turned to Congress, and Congress passed these new bills. And I think something like this will happen.
Can I add some thinking? This is actually directly relevant to what we're talking about. So, it's kind of amazing. So Grokster, again, what Grokster found, if there was anything unique about it, it said, by creating a piece of software that will be used to copy songs, you are liable for copyright infringement. And again, I would say that it did make a little new law, because up until now I would say it was unclear when and how that would constitute actually being an infringer. But it wasn't some groundbreaking. I totally understand. So the court just announced a couple hours ago that it granted cert. It will hear next year a case on this exact subject. It's fairly amazing that this just came up. So they've granted cert in a case called Cox Communications. In Cox, the Fourth Circuit Court of Appeals found that Cox was liable for contributory copyright infringement because it knew of accounts that were being used to infringe copyrights. It knew of the accounts, it knew how they were being used, but it refused to take them down. The Fourth Circuit, on a similar kind of logic to Grokster, said that they could be liable and they're not protected just because they're a platform. So this whole question of, the protection that platforms get, at what point, what kind of knowledge do they have to have before they actually have some affirmative duty to do something? And if they don't do it, they become contributorily liable for copyright infringement. So the Fourth Circuit said Cox was liable, but the Supreme Court has just granted cert. That doesn't necessarily mean they're going to overturn the Fourth Circuit, but it does mean that the case is going to be argued next term.
And so to that point, I didn't want to bring it up because it's a very complicated thing. Is that the other thing that Grokster did was that it brought in this concept of indirect infringement from that was being practiced or was a legal theory in patent law for over 100 years, brought that into copyright law. And so again, didn't make new law, but applied already existing law to a new situation.
Well, this has been brilliant, and I really honestly, Sam and Steve, thank you so much for playing along with this, because I feel like I'm learning so much right now, and I really wish we could go on for another hour. I feel like this is a good time to begin to take the slow descent down, probably a faster descent down. So how about if anyone has any final thoughts, anyone on stage will land this plane, and hopefully all of us walk out safe and alive and ready to meet our family members.
So I do apologize earlier about seemingly going off topic with data sovereignty. But if you listen carefully to the conversation that was had, it eventually gets narrowed down to data sovereignty. Data data sovereignty is the control of data you generate, including where it can be stored, who can access it, and how it can be used. And the amount of biometric behavioral data that we emit on our devices, even on this platform itself, a lot can be told. A lot can be found out about one's personality and a lot of behavioral biometrics. So that data can therefore be used to generate deepfakes, and this is why data sovereignty is essential to the conversation eventually.
Yeah, thank you for that, dude. I really appreciate that. Anyone else? Well, doing the kind of the 3-second countdown in my brain. If no one else has any comments, today was a discussion by Sam and Steve on upcoming Denmark law and some related topics of data sovereignty and all sorts of other things. This was really this was awesome and totally spontaneous, and I really just appreciated listening and learning a bit. And so I guess here we are. Time to go. See you all tomorrow morning at 7:30 a.m. Pacific Daylight Time. Goodbye, everyone.
Tell your defense lawyer to tell the jury that this is a modern love story. This man is delusional. We already know.
And having been a financial advisor in the town that Dell started in for a long time, there's all sorts of stories, but there's a shit ton of people that have been at Dell and have basically the same experience, that you get washed through this middle management set of BS, and